Hi everyone. In the wake of the latest controversy at JNU and the arrest of JNU student government Kanhaiya Kumar, there has been a nationwide debate on sedition and the law of sedition. I'm Avani Bansal, an advocate in India, currently pursuing a master's at Harvard Law School, and I thought of making a short video explaining to everyone out there what the law on sedition is. At the outset, I should say that since the matter is before the court, neither I nor anybody else can comment directly on the facts and legalities of the case involved. However, I thought it is pertinent that the layman in the country understands what the law on sedition in India is. Let's take a straight dive into Section 124A of Indian Penal Code. This is a section that defines what sedition is. Now, before I come into my commentary, let's just take you directly through the bare provision itself. I bring you straight to the main content of the section. It says, and I quote, whoever by acts visible or by visual representation, either by words spoken or written, and now I quote, brings or attempts to bring to hatred or contempt, or excites or attempts to excite disaffection towards the government of India established by law. Now, kindly note the word disaffection towards the government. At least at the first look, it looks like quite a broad word that could mean a lot of things. Hence, the explanation comes to a rescue and says that trying to invoke any feelings of enmity is also, or enmity or feelings of disloyalty is included within the definition of the word disaffection. The second explanation goes on to clarify that any criticism of the government policy per se is not covered within the definition of sedition. So if a person is vociferously arguing against certain measures taken by the government and asks for replacement of it without inciting law and order or creating a law and order situation, that will not be covered under the definition of sedition. However, even the terms that have been used under this section, such as enmity or disloyalty or disaffection, it has been criticized by several commentators and scholars that these words are too wide to be properly interpreted and it has to be ultimately on the facts of a certain case. So the police as such does not have much guidance on determining whether or not a certain situation can be categorized as sedition and whether or not to slap the charges of sedition when arresting a particular person. A few things worth noting here. First, the charge of sedition is a cognizable offense in India. What that means is that in India, the police can arrest a person without a warrant if the charges that have been framed are that of sedition. Secondly, this section 124 Indian Penal Code, have been criticized for a long time, and to understand the controversy behind it, it is important to step back and look at the background of the section. This section came into being during the British rule, who primarily used this section against people who were raising a voice against the Britishers and were taking an active part in the freedom struggle of India. Most notably, the section has been used against people like Bhagat Singh, Mahatma Gandhi, and in recent times, after India's independence, we have seen it being used against people like Arundhati Roy, somebody known for having controversial views, or at least so the majority thinks, and people like Dr. Binayak Sen, who got both the national and international support from around the world, saying that this was not the right thing to do. He's a humanitarian who has been doing wonderful work in the state of Chhattisgarh, and he was somebody who was charged with sedition. Most notably, however, there was one time when 3,000 people were all framed under the charges of sedition for protesting against a nuclear power plant. Now, if you have a basic understanding of the Indian Constitution, you would think of Article 19, which categorically lays down that every citizen in India has the right to free speech and expression. That means I, as an individual, can voice my opinion irrespective of whether the majority in the country is agreeable to it or not. However, let's be very clear, nobody is talking about an absolute right of freedom of speech and expression. In this debate on JNU, on the social media and otherwise, I've seen several people say, but you live in a democracy, clearly you cannot have an absolute right to say whatever it is that you want to say. And there is no debate on that whatsoever. There is nothing called an absolute right in India. Even under Article 19A, which talks about freedom of speech and expression, Article 19.2 then goes on to lay down some reasonable restrictions, saying on what basis can your freedom of speech and expression be limited? What are these grounds, you may ask? Some of these grounds include things like threatening the security of the state, or any act that disturbs foreign relations with other states, that creates a public disorder or public law and order situation, or is against the morality, so on and so forth. Which means nobody is talking about an absolute right to freedom of speech and expression. However, since it is a fundamental right, the threshold of when it can be limited is rather high. Now, coming to sedition, if freedom of speech and expression is this kind of big ball, and there are specific grounds on which it can be limited, which are laid down under Article 19(2), as I just explained to you, then sedition is one of the gravest offences against which you can be charged, also because it is a cognizable offence. Now, look at some of the Supreme Court judgments and let us try and see if there has been any guidelines whatsoever that the Supreme Court has laid down in determining what is sedition and what is not. Now, there are several cases, and since we have less time, let me take you to the two most important cases. The first case is Kedarnath Singh versus State of Bihar. It's a 1962 judgment where the constitutionality of Section 124A Indian Penal Code was brought into question. Now, looking at several facts and the laws, the court laid down that there has to be a fine balance that has to be struck between the individual right of freedom of speech and expression and the state's right to maintain law and order situation. So the court said that Section 124A is constitutionally valid. However, the court went on to say that unless the act intends to or has a tendency to create a law and order situation, mere words alone will not suffice to fulfill the requirements of the law of sedition. Let's look at another judgment. This is Balwant Singh versus State of Punjab, 1995. Interestingly, we are recording this video on 1st of March and the judgment came out on 1st of March 1995. The court there said there were two people who raised several slogans, notably Khalistan Zindabad, Raj Karega Khalsa. And the court said this was a time when this was the date of assassination of Indira Gandhi when these slogans were raised. And the court said that mere raising of slogans without any proof that other people joined in raising those slogans or that there was a law and order situation will not amount to sedition. In fact, the court went on to say that the police in that case acted with a lot of oversensitiveness, and the court went on to say that in tense situations like these where a particular matter is being debated hotly in the country, the police should show maturity because oversensitiveness, according to the court, could be counterproductive. Now, in this case, whether the police acted rightfully or wrongfully, whether the words that are being alleged to be spoken by Kanhaiya Kumar were spoken by him, whether the slogans which what we are debating, whether they form sedition or not, were said by Kanhaiya Kumar or not, what was the exact consequence of events, when did the event at JNU making or speaking or debating on Afzal Guru took place, when did Kanhaiya Kumar's speech took place, when were the slogans shouted. Now, all of this is for the court to determine. But through this video, I hope I've tried to communicate two very important points to you. One is that in India and around the world, we have seen that a democracy, to be a robust democracy, it is important that people criticize each other's views, especially the views and policies of the government, without any fear of being framed. And the only time the law of sedition comes into play is when there is a grave threat to the sovereignty of the country, to disturbing relations with a future country, or there is a grave law and order situation, or at least there's a clear proof that there will be a law and order situation. In the absence of these things, the law of sedition is very, very difficult to be fulfilled. And secondly, and most important point that is to be made through this video, I hope, is that sedition is a complex law. It has also been said to be an archaic law simply because of its vagueness and because of its broadness. Therefore, it is for the court to see from a case-to-case basis whether the requirements of sedition are fulfilled or not. There have been a group of people who have been advocating for a further amendment to Section 124A in the Indian Penal Code. I join you in hoping that the court will come out with the best judgment in this case possible. Stay tuned, and we will see each other more often looking at the overviews and pertinent laws, and I think the entire country should be discussing and debating. Thank you so much for watching. I'm Avani Bansal at Harvard Law School. Thank you.